If you've been injured in an accident in Iowa, you probably have a lot of questions. You may be wondering, do I have a case? How hard is it to win a personal injury claim? What is my case worth? How long is it going to take? How much is it going to cost? And what actually happens if a lawsuit gets filed? These are all completely normal questions. Most people in Iowa will never hire a personal injury lawyer in their lifetime. And most people who contact a personal injury lawyer have never done it before. So in this video, I want to walk you through the complete process all in one place. We'll talk about what an Iowa personal injury claim is, what has to be proven, how cases are investigated, how attorneys' fees work, how long cases usually take, what happens if a lawsuit is filed, and then finally, my background, experience, and philosophy as an Iowa personal injury attorney. My name is Craig Steger, and I'm a personal injury attorney practicing in Iowa, Minnesota, and Wisconsin. I've handled serious personal injury claims for more than 20 years. I want to start by talking about who this video is for. This video is for people or family members of people who've experienced a personal injury in Iowa as a result of someone else's fault. Now, let's start with the personal injury side of this. That simply means something that required medical care. Maybe it caused time away from work or created ongoing pain or discomfort. Second, it has to be because of someone else's fault, not your fault, not an act of God or nature. And I'll talk a little more about that in a moment. Who is this video not for? This video is not for people who have not sustained a personal injury. It's not for people dealing only with property damage. It's not for medical malpractice victims. Those are a different category of personal injury with their own special rules. And it's not for people who were injured because of their own fault or maybe nobody's fault, such as hitting a deer. These situations may involve insurance questions, but they don't necessarily create a personal injury case. So, what is a personal injury claim? A personal injury claim arises when someone is injured and that injury was caused by another person's fault. And we usually call that negligence. In other words, someone else acted carelessly and then their carelessness caused harm. Personal injury law is designed to do one basic thing. It assigns responsibility for injuries and then provides a legal way for injured people to recover compensation for whatever losses that they've suffered as a result of that negligence. Those losses will include things like medical bills, any lost income or wages, damages to property, and then sort of the personal impact of the injury on a person's life. Now, not every accident automatically creates a legal claim. For a case to succeed, there are certain legal elements that have to be proven. So, how hard is it to win a personal injury case? Well, personal injury cases really come down to proof. You see, insurance companies don't simply pay claims because someone was injured. The notable exception to that is workers' compensation, and I'll talk about that in a moment. To succeed in a personal injury case, there must be evidence showing that someone else was legally responsible for causing that injury. The evidence that supports the negligence includes things like, police or accident reports, maybe your medical records, if there's any photographs or video from the scene, witness statements, surveillance footage, and sometimes expert opinions like accident reconstructionists. The difficulty of a case generally depends on several different things. Number one is probably how clear is the fault? Does the other person acknowledge they were at fault or do they dispute that? How serious is the injury? Is it a minor injury or something that requires surgery or worse? How well is the evidence documented about what happened? Is there any photographs or video of the incident? Is there insurance coverage? And sometimes, are the people involved credible? Those are all things that go into how strong a personal injury case is. I want to talk a little bit about workplace injuries. Now, one area that can cause confusion for people is the relationship between workers' compensation and personal injury claims if someone's injured in the course of work. In most workplace injuries, employees cannot sue their employer directly. Instead, the law typically provides workers' compensation benefits, and they're laid out by statute or administrative code. And workers' compensation typically covers medical care, and a portion of lost wages. And that's regardless of who caused the accident, even if you caused your own injuries. Now, the trade off for providing that coverage, regardless of fault, is that it sometimes limits the damages that can be recovered against the employer or another employee, even if they were actively responsible for causing your injuries. Typically, we call that the exclusive remedy rule. And that generally applies to work injuries, even if they're caused by your employer or co-employee. Now, there is an important exception to that rule. You see, if someone other than your employer or maybe another employee caused your injury, a separate personal injury claim may still exist, and we call those third-party claims. For example, imagine a truck driver who's injured in a crash by another car, another motorist, or maybe a delivery person on the job and they slip and fall while delivering packages at another business, or maybe someone that's working on a farm and they get injured because the farm machinery is defective. You see, in those situations, there may be two claims happening at the same time. There may be workers' compensation benefits through the employer and their insurance company, and then a civil injury claim against the negligent party or corporation or their insurance company. That civil claim may allow recovery of damages that workers' compensation simply doesn't recognize. So that's why understanding who was responsible for a work injury is a really key part of those cases. Generally speaking, there are four proofs of negligence. So to win a personal injury case, you got to prove negligence. And that generally requires first to show that there was a duty of care. Second, that someone acted carelessly, unreasonably, or violated that duty of care. Third, that carelessness caused an accident. And that four, the accident caused injuries or damages to someone else. We often describe that as duty, breach, causation, and damages, but the core idea is the same. Now, someone's carelessness has to have caused the harm. A simple example might be, let's say, a driver who runs a red light while you're traveling through an intersection and they cause a crash. You see, running the red light is that negligent act. The collision is what that act caused, and then the injuries and damages are the result. Now, even when someone is injured, there still must be proof of fault. Sometimes injuries occur from accidents, but there actually isn't a legal case. For example, suppose you're driving home from work and you fall asleep at the wheel and you run off the road and get injured. Or let's say another driver has a medical emergency and that's the reason why they drove through a red light and caused a collision at an intersection. If no other driver or entity contributed to the crash, there is no defendant to sue. You see, you can't sue yourself for your own fault. Or maybe let's say a driver driving down the road, it's a rural road in Iowa, and they hit a deer on the highway. That can cause serious injuries, but generally there's no negligent party responsible for that deer entering the roadway. That's just kind of one of the risks you take driving in Iowa. Now, we can distinguish that, let's say, from a situation where you're driving down the road and let's say cattle have escaped from inside a farmyard or outside of a fence and they wander onto the road and that causes an accident. Now, depending on the facts, there may be a case against the farmer, or maybe someone went through the fence and allowed the cattle to escape. And there's other examples as well, such as, let's say, a mechanical failure that wasn't reasonably discoverable before it happened, or sometimes natural conditions like snow and ice during a snowstorm in Iowa. These events can be serious and tragic, but personal injury law requires negligence by someone. Without negligence, there generally is not a case. Now, for many people, calling a lawyer for the first time can feel intimidated. You may be wondering, what am I supposed to say? Are they going to charge me? What if I leave something out that's important? Am I going to be pressured to sign a contract or go to a lawsuit right away? These are all normal questions, and the first step is usually called an initial consultation. A lot of times this is on the phone, but it could be in person, it could be by video, it could be by messages and email. In personal injury cases, that initial consultation should be free, and you should be able to talk to multiple lawyers before you decide who's the right fit for you. During that initial conversation, the lawyer or someone from their law firm is going to ask you to describe what happened so that they can gather the basic information about the accident and your injuries. Typical things they'll be looking for is like when and where the accident happened, who was involved, what kinds of injuries were sustained, did you get medical treatment right away, did you ride in an ambulance or take a car to the doctor, and have you spoken with any insurance companies or have you given a recorded statement? Now, as you describe what happened, the lawyer or their law firm may ask some follow-up questions to make sure they fully understand the case. For example, like where exactly did the accident happen? Knowing which state it happened in is very important. What county, city, intersection, maybe which lane of travel you were in. Was law enforcement involved? Was that the police, sheriff, maybe the highway patrol? They'll probably want to know, like, did you receive medical care the same day or how long until you went to the doctor or the hospital? Do you know who owns the vehicles involved, including the one that you may have been driving or a passenger in? They may ask if you're dealing with any injuries or health conditions that may have, let's say, predated the accident but were aggravated by the incident. You see, these questions are not really meant to embarrass you or put you on the spot. They're there to make sure the lawyer understands the facts. Now, one of the first things a law firm will do is ask about all the people involved, including other drivers and insurance companies. And the main reason for this is to check for any conflicts of interest. Law firms have ethical obligations that prevent them from representing both sides of the same dispute, or sometimes even one party, if that law firm is already representing another party involved in an unrelated matter. Let's say, for example, the other driver that caused your accident is going through a divorce and they're represented by another lawyer in that law firm. That may present a conflict of interest. Generally, there is no conflict, but if there is, the lawyer should tell you right away, and they may even be able to help point you towards someone who can help you. There's really two main goals of that initial consultation with the lawyer's office. First, it helps the lawyer and their staff understand what happened and decide, first of all, if they're even able to help you. And then, second of all, it helps you decide whether you want to work with that lawyer or their law firm and if you want them to represent you. If you have documents like, let's say, like police reports, photos, video, any insurance information, if you have been to the doctor and have medical paperwork, that can all be helpful to have with you at that initial consultation. But don't worry if you don't have everything organized before making the call. That consultation is simply a conversation, and there'll be follow-up calls if necessary to make sure everyone has all the information that they need. If your first contact with a lawyer is a phone call, you can, if you want, ask them to allow you to meet in person or maybe do by Zoom or some other video platform. Usually the lawyer should be able to accommodate that for you. The most important thing is to make sure that that first consultation happens at a time and in a setting that is comfortable for you so that you can make a really good decision. Don't feel pressured to sign a contract while you're still on the phone unless you're confident this is the right lawyer for you. Take the time it takes to make sure that that lawyer and the law firm are the right firm for you, and talk to other lawyers first if you're unsure. Now, one of the biggest questions people have is how much does it cost to hire a personal injury lawyer? Most personal injury lawyers in Iowa work on what's called a contingency fee basis. That simply means you generally don't pay the attorney's fees up front. Instead, the lawyer is paid a percentage of whatever recovery there is. If there's no recovery, the lawyer usually does not recover a fee. What does a recovery mean? A recovery is simply the money that is obtained as compensation for the injury. That money will often come from an insurance policy or sometimes some sort of a settlement resolution or maybe a trial verdict. Recovery may include things such as compensation for your medical expenses, lost income, any future medical care, pain, suffering, disability, and other kinds of damages. Now, I want to talk a little bit about the difference between attorney's fees and case expenses because they're not the same thing. Attorney's fees are the percentage paid for the legal representation. Case expenses are the cost required to develop and pursue the case. Examples of case expenses might include charges for getting medical records, court filing fees, retainers if we have to hire expert witnesses, deposition transcripts, and things of that nature. In most personal injury cases, the lawyer will simply advance those costs, which means we pay them during the case and then simply get reimbursed from the recovery later. Usually, on a contingency fee agreement, the lawyer's fees are a percentage taken off the top, and then those case expenses are reimbursed after that. You should make sure that the fee agreement clearly explains how case expenses are handled. And if you have any questions about that, make sure you ask the lawyer so that you're not confused. Now, one thing I want to talk about now is liens and subrogation. So a lien is something like, let's say, a hospital lien or maybe a mechanic's lien if you had to have your car repaired. Those may be something that get paid out of the settlement or out of a trial result. We also have things called subrogation liens, and that's where, let's say, another insurance company, let's say your health insurance company, pays for some of your damages, and then when there's a settlement, they're generally entitled under law to a reimbursement from your recovery. And this should be something that should be explained to you. And if you have any questions about that process, make sure you ask the lawyer. Now, you may be worrying about what if I say the wrong thing when I talk to a lawyer. I say the most important thing is just to be honest. You don't need to remember everything perfectly, but it's really important that you not hide things such as, let's say, prior injuries, prior accidents, any prior conversations you had with the other party or the insurance company, maybe their adjuster. Lawyers can work with difficult facts, but what causes problems later are surprises. Now, once a lawyer is hired, the firm begins evaluating and investigating your case. They'll gather medical records, medical bills, police and crash reports, gather insurance information and insurance policies. They'll try to preserve any photographs and videos, get your employment file if you missed work, and any other documentation relevant to your claim. Now, one of the early steps that a lawyer will do will be sending preservation letters to make sure that important evidence is not destroyed. Depending on the case, that could include black box data from vehicles, it could be maintenance records, accident reports, other electronic information that can go lost if it's not otherwise preserved. For example, if an accident happened with businesses or maybe homes nearby, sometimes those businesses will have surveillance or security cameras, especially gas stations. Those security cameras sometimes will capture the incident. If that footage exists, it needs to be requested pretty quickly, otherwise it gets deleted. You see a lot of camera systems, they simply overwrite old footage within days or weeks if no one requests that that evidence be preserved. Having video proof of the accident can make a huge difference later on. Now, once you hire a lawyer, the lawyer will typically notify the insurance companies involved. The insurance company is told that a claim is being made or might be made, and that all future communication should go through the lawyer rather than through the client. This protects you from unnecessary pressure and phone calls from insurance adjusters. Now, one of the most important things that the lawyer does as soon as possible is try to identify all potential insurance companies and any policies that may provide coverage. If injuries are severe, it can take multiple policies to get you full compensation. One of the other important things the lawyer will do early on is to identify any legal deadlines that it may apply. That's why it's really important to know exactly when the accident or your injuries happened. The statute of limitations is the deadline for filing a lawsuit. Now, in Iowa, that deadline is typically 2 years from the date of injury, but different rules can apply depending on the facts. So it's just really important to talk to an Iowa personal injury lawyer as soon as you reasonably can. Now, once the legal process begins, once you've hired a lawyer, your main focus should be on medical treatment and just recovering from your injuries. But there are a few important things that you can do to help move your case along more smoothly. Number one is make sure that you're following your doctor's recommendations and you're doing the treatment that they recommend. Let your lawyers know if anything changes, if they prescribe any new treatment, maybe they send you to a specialist, or maybe your work situation changes. These updates help your lawyer understand how the injury is affecting your health and your livelihood, and sometimes we communicate that to the insurance company so they understand what's going on. You're generally advised to avoid discussing the case publicly and especially on social media. Insurance companies like to monitor people's social media posts and take those comments and use them against them later on. Be sure to talk to your lawyer, though, before deleting any posts that already exist. Now I want to talk about how insurance works in injury cases, because a lot of people may assume that there's only one insurance policy typically involved, but in reality, there's often different types of coverage that may apply. Maybe the most obvious is liability insurance. That's the insurance carried by the person responsible for causing the accident, whether it's auto insurance or homeowners or, let's say, business insurance. Liability insurance may cover medical expenses, lost wages, and other damages caused by negligence. There may also be a separate property damage coverage that may apply to vehicles, equipment, or personal property, maybe rental coverage. You see, the property claims tend to get involved earlier on before the injury claims because the property damages can usually be evaluated more quickly, and there isn't always as much dispute about that. You may also have medical payments coverage under your auto policy. Call that MedPay. MedPay simply covers some of the basic early medical expenses, maybe an ER visit, ambulance ride, and that's there regardless of who's at fault. That coverage usually comes from the injured person's own auto policy or the policy on the vehicle involved. Health insurance may cover your medical expenses while the case is pending, but you have to realize is when if a health insurance company, or let's say Medicare or Medicaid, pays for accident related medical expenses, they generally have a right to reimbursement from any settlement later on. We call that subrogation. Now, what is a personal injury case worth? Well, when negligence and causation can be proven, the next question is often, well, what is my case worth? Damages and personal injury generally fall into two categories. Economic damages are the financial losses caused by the injury. These can often be documented with records, bills, invoices, things like medical expenses, ER visits, ambulance rides, let's say x-rays and MRIs, things like that, any prescription medications, lost wages, reduced earning capacity, property damage, sometimes, rental cost if you have to get a rental car while your vehicle is being repaired or replaced. Those are what we call economic damages. The second category is non-economic damages. Non-economic damages are sort of those intangible human impacts of an injury. They're real, but they often don't come with a receipt. You can't look them up in a blue book. Non-economic damages includes things like pain, suffering, disability or impairment, emotional distress, maybe disfigurement, loss of enjoyment of life. And we also have something called loss of spousal consortium if you were married at the time of the accident. That refers to loss of companionship, support, and marital relationship that may occur when when spouse suffers a serious injury. There may also be a claim for children if their parent gets injured. In tragic situations where injuries result in death, Iowa law allows certain family members to bring a wrongful death claim, such as, let's say, a surviving spouse or children. These claims may include damages such as medical expenses for their final injury, funeral and burial expenses, loss of financial support, loss of society and companionship. Now, Iowa law typically requires wrongful death claims to be brought by the deceased person's estate, so it's important to talk to an attorney as soon as possible so they can get that set up well before the statute of limitations is set to run out. Now, how long does an Iowa personal injury case? Well, that's a very reasonable question, and if you've been injured, your life already feels disrupted. So here's the lawyer answer. It depends. But the simple answer is however long it takes for you to fully heal from your injuries, or however long it takes for doctors to determine have you reached maximum medical improvement and what does your future hold? Iowa personal injury cases tend to move in phases. There are four distinct phases to an Iowa personal injury claim. First is medical treatment and stabilization. Second is investigation and case development. Third is negotiation with the insurance company or the responsible party. And fourth, if necessary, a lawsuit. Not every case reaches the fourth case phase and results in a lawsuit. But understanding all four can help you understand kind of what's going on and who controls the clock depending on the phase that you're in. Now, the first phase is medical treatment and stabilization. A lot of times this can be the longest part of the case. You see, before a case can be resolved, we need to understand your full diagnosis and medical picture. What treatments have you had? Is surgery going to be required? Are there any permanent limitations or restrictions? And are you going to need any future treatment? You see, if you try to resolve a case too early before we know that and before your condition stabilizes, you risk leaving money on the table, especially if your condition gets worse over time. In personal injury law, we often talk about maximum medical improvement, or MMI. That simply means that your condition has stabilized enough that doctors can reasonably evaluate the long-term impact and give predictions or opinions about the future. Until that happens, it's often premature and risky to settle too early. The second phase is investigation and case, and this investigation of the case and case development, and this can sort of happen simultaneously with phase one. So while you're treating, your legal team is developing your case, and they're gathering medical records, getting doctor bills, they're reviewing police reports, photos, videos, talking to experts, analyzing insurance policies, things of that nature. If liability is clear and injuries are straightforward, this phase may move fairly quickly. However, if fault is disputed, if there's multiple parties involved or multiple injured people, or if insurance coverage is complicated, that phase can take a little longer. The goal of this is not to speed through this phase, is to make sure that we're accurate and we have everything prepared for the next phase, which is negotiation. So the third phase is what we call negotiation. So once your medical condition is stabilized enough so that we understand the scope of your damages, we tend to move into a negotiation stage. This usually involves preparing a very detailed written demand package and sending it to the insurance company for whoever party is responsible, or multiple parties if there are multiple people responsible. That demand package will summarize your injuries, lay out your treatment, all your medical expenses, wage loss, and discuss sort of the overall impact that the injury has had on your life. That package gets sent to the insurance company, who then reviews the material. That can take some time, especially if it's a lot of new information and documents to them. You see, insurance companies have internal procedures, supervisors, they have case evaluation meetings. A lot of cases, or at least some cases, do resolve during this phase, while others may require multiple rounds of negotiation, going back and forth and negotiating to see if a mutually agreeable resolution can be reached. If negotiation is unsuccessful, or let's say the statute of limitations is coming up and something needs to be done, the fourth phase is filing a lawsuit. Now, filing a lawsuit does not mean that you're going to trial right away. In fact, trial seldom happens less than a year after the lawsuit starts, and sometimes it can take 2 or even more years before it gets to trial. Filing a lawsuit simply moves your case into the court system, where there's going to be deadlines set. There'll be a judge assigned to the case that can resolve any disputes that may arise between the parties. In Iowa, this phase usually involves disclosure of written information and documents to the parties, depositions where parties and witnesses are questioned under oath. There may be motions with the court. There may be court-required mediation or other ADR, alternative dispute resolution, and then eventually a trial date. You see, trials are often last somewhere from, let's say, a couple days to maybe even a few weeks, although in my experience, most trials in Iowa personal injury cases are completed in a week or less. Now, even after a lawsuit is filed, many cases will still settle before trial. Now, there are typically 5 steps of a personal injury lawsuit in Iowa. The first step is the filing of the summons and complaint. Those are the legal documents that talk about the case, identify the parties, the causes of action, and then those are served on the responsible party, sometimes their insurance company, by the sheriff or a process server. That's step 1. Step 2 is what we call discovery, and that's where both sides exchange information, maybe exchange documents, take depositions. The third step is what we call pretrial motions and mediation. So sometimes there are legal issues in the case, maybe fights about a witness or a certain type of evidence, or whether a party is entitled to certain information from the other side. Sometimes a judge will rule on that. We call those motions. And then also is the mediation. I mentioned that before. That's something that usually the judges will require the parties to do. And that's it's something done with a neutral party, often a retired judge or maybe an experienced civil injury attorney, who will serve as a neutral party between the parties. Will usually meet at someone's office, and they'll go back and forth to try to help the parties settle the case. In most cases, do settle by mediation. If that is unsuccessful, the fourth step is an actual trial. And then the fifth step, which is, in my experience, pretty rare, is an appeal if either party disagrees with the trial result or maybe a motion. Most cases ultimately do resolve during discovery or mediation before trial ever happens. So I'm going to talk a little bit about comparative fault because Iowa uses a comparative fault rule. That means if an injured person is partially responsible for an accident, your damages may be reduced in proportion to whatever fault that you have. Let's say, for example, you're 30% at fault. Your damages, whatever they are then reduced by 30%. However, if the plaintiff or the person that's injured is more at fault than the other party, that generally bars any recovery. So if a case goes to trial and there's a dispute about who is at fault or how much fault each side has, the jury will be asked to divide fault among all the responsible parties, totaling 100% of fault. That rule, and if there are disputes about who's at fault, can have a major impact on how cases are evaluated and how successful settlement and mediation will be. Now, if you're considering hiring a personal injury lawyer, it's completely reasonable and normal for you to want to know who you're dealing with. When you're hiring a personal injury lawyer for an injury case, you're trusting that person with something that's very important to you and your family. So let me tell you a little bit about my background, my experience, and how I approach injury cases in Iowa. I was born on a small dairy farm in northeast Iowa. Later, my family relocated to South Dakota, where we operated a large beef ranch. Today, I live on a small acreage in western Wisconsin with my wife and our 9 children. Raising up on a farm teaches you certain things early on: hard work, resourcefulness, and that you don't work from 9 to 5. You work until the job is done, whether you feel like it or not. That background helps shape how I think about legal work and how I approach my own cases. Now, why did I become a lawyer? You see, the law wasn't my first plan. I originally intended actually to become a priest, and I studied for that in Winona, Minnesota. When I decided to leave that path, I still had a strong desire to help people and do work that was important and challenging to me. A priest friend actually recommended that I go to law school, and that turned out to be some of the best advice I've ever been given. Personal injury law, in particular, gives me an opportunity to help people during some of the hardest, most difficult times of their lives. The legal work isn't really about arguing, it's about a lot of listening and preparing and understanding how the facts all fit together, and then presenting those facts with the law in a way that is clear so that judges or juries can understand it. I'm a civil trial attorney. That means I prepare each case as if it may ultimately be presented to a jury. Fortunately, not every case goes to trial. In fact, most cases do not. But the possibility of trial shapes how a case is prepared from the very beginning. Insurance adjusters can tell whether a lawyer is actually willing to take a case to trial or whether that lawyer will eventually cave. Knowing that your lawyer will take a case to trial when necessary is one of the biggest factors in getting maximum recovery. Over the years, I've handled a range of serious injury matters. My practice focuses on injury and civil litigation. That includes car accidents, commercial vehicle and trucking cases. I actually have a commercial driver's license, and I drive truck when I get the chance. I also handle farm-related injuries and work-related injuries, and other serious injury claims where liability and damages are, let's say, unusual or complex. My courtroom philosophy is pretty straightforward. I try to prepare my case thoroughly from the very beginning of the case until the end. I try to be honest and transparent with my clients, judges, jurors, even insurance adjusters. I try to present the evidence clearly and respect the intelligence of the judge and the jury, avoiding exaggeration or pursuing claims that I simply cannot win. Because of my background, I think I understand rural and working communities in a special way. I understand physical labor. I understand what it means when an injury affects your ability to work with your hands. I understand how difficult it can be to pay the bills when you can't go to work. And I especially understand the importance of being able to play with your kids and attend their important life activities. That influences how I handle cases and how I communicate with my clients. I'm licensed in Wisconsin, Minnesota, and Iowa in both state and federal courts. You see, in western Wisconsin, southeast Minnesota, and northeast Iowa, people regularly travel across state lines for work, business, and just everyday life. That flexibility gives me maximum options in handling cases that involve multiple states and helps me choose the court system that best fits the particular needs of my client and their case. When someone contacts my office, I try to listen and gather as much information as I can about them and their case and what really matters to them. I try to give my honest opinions. I don't sugarcoat things, and I try to make sure my clients understand their options so that they can make informed decisions. I want clients to believe that I'm actually the best lawyer for their case. And if I don't think I'm the best lawyer for them, I'll try to find them someone who is. I'm not a volume based operation. You probably won't see me on billboards or gas pumps. I'm not into quick settlements, especially if they don't reflect the seriousness of the injury. I try to use my experience, my background, and my firm's resources to work every client's case in the best possible way. If you've made it this far, here's the big picture. Iowa personal injury cases are based on negligence, and that negligence has to be proven. The injuries and damages have to be documented. Insurance coverage needs to be understood. We need to allow time for medical recovery so that doctors can determine the long-term impact of your injuries. If you're considering hiring a personal injury lawyer, you should know that the first consultation should be free, and you're free to talk to more than one attorney before making a decision. Most of all, make sure that the lawyer you hire is someone you trust to handle something very important. These cases are about your health, your work, and your finances and your future. If you're in that situation, take your time, get informed, ask questions, and then make the decision that's the right fit for you and your family.